Thanks for staying with the Pulse today. We continue our conversation on the decision by Judge Davis to declare lockdown regulations on level 3 and 4 unconstitutional. Now, can that judgment survive an appeal? We speak to constitutional law expert Pierre De Vos. Pierre, good evening. It's a pleasure to have you with us tonight. Now, already last night, just from the extracts of the judgment, you were already kind of saying, look, I'm not sure about the rigor that has been applied to the arguments within this judgment. You've had time to think about it some more. Do you still think that's the case?
Yes, well, I think that the judgment makes excellent points of principle because it explains that if you're going to limit people's rights in the way that the regulations did, for very good reasons, of course, then you have to justify it, and you have to show that there's some link between your regulation and the purpose. But then it went on, and it seemed to be saying that all the regulations are irrational. There were 2 or 3 exceptions, but the court didn't actually discuss each and every regulation to say why each one is irrational. It cherry-picked a few, said these are irrational, so the whole thing is unconstitutional, which is not, I think, usually how the litigation is supposed to work.
How much of that rests on the fact that the submissions that were made by the DG of the Cooperative Governance Department didn't seem to include much details in terms of the thinking of the state when implementing many of these regulations?
Yes, the court also picked up on that and said that there was not a lot of specifics. This has been a complaint from the public and from lawyers about various aspects of how the lockdown have been regulated. And specifically, the DG said, well, we are doing this for the benefit of the public, for the public good. And so that means that the end justify the means, although he put it the other way around, which is not really how the law works. You can't say that you can basically take any steps as long as it's for a good cause. The steps must be necessary. It must be linked to the purpose of why you're taking the steps. And of course, if it's limiting rights, it has to be limited only to the extent justifiable by the Bill of Rights.
So now, given then the limitation in terms of information on what informed many of these regulations and this period that we're in of, needing an immediate response to this pandemic, there are those who are saying the judge, in formulating his own findings, went a bit too far in his conclusions, and that, in fact, parts of this judgment point to judicial overreach. What do you say to that?
Well, I will say that obviously the way the whole case was litigated was not particularly good from both sides. And so there was a limited information. So in those cases, it is wise for a judge to be a little bit circumspect. In this case, the judge wasn't always very circumspect about specific issues. For example, about hairdressers, he said it's completely irrational that hairdressing has been prohibited. While there are, although these were not arguments made by the respondents, there are very good reasons for limiting access to hairdressers because the possibility of transmission of the virus is much higher than, say, if you sit in an office or you do other kind of work where you're not so intimately involved with clients.
Sure. One of the things that, of course, was also mentioned were the numerous other cases that were targeting specific legislation when it comes to the enforcement of this lockdown, and the judge intimating that it's not a desirable situation. Are we likely to see the Constitutional Court hearing all of these cases concurrently, or is it simply impossible given the different interests that are at play?
Well, it's not the different interest that is difficult. It is the fact that the cases are not always dealing with or raising the same legal issue. So some of the cases deal with the powers of the National Command Council. Some deal with the constitutionality of the Disaster Management Act, which wasn't the case in this particular judgment. And some deal with the delegation of power to the minister to make the regulation. So each one is slightly different in the kind of legal issue that it raises. I don't think that it's necessarily bad that people go to court, because it's one of the options that people have to make sure that all the legal rules that are implemented are actually compliant with the Constitution. And of course, as a final resort, people will go to the court to see that tested. Sometimes the court will agree with you, and sometimes it will reject your argument.
It sounds like government is leaning towards an appeal, Pierre. So then, for the long-term projections of this case, is it likely to get wrapped up before we even get to level 1 of the lockdown?
Yeah, it's very difficult to know. If there's an appeal, what we do know, that will suspend the order by the judge, and so there would not have to be a rewriting of the regulations. They will stay in force. And then it really depends how the parties litigate, whether they go to the Supreme Court of Appeal first and then to the Constitutional Court. That can delay things. And of course, it depends on when we will actually go to level 2 and level 1. We don't really know that. That is completely unknowable at this point.
All right. Pierre De Vos, let's leave it there. Constitutional law expert, giving us then his roundup of that judgment from Judge Davis.